Welcome to yet another episode of Shortcast over Coffee. My guest today is Murali Neelakantan. Murali is a graduate of the 96 batch of the NLSIU and was one of the first India educated lawyers to have become a partner in an English law firm. After moving back to India, he worked as a senior partner at Khaitan and Company before joining Cipla as a Global General Counsel. After Cipla, Murali is currently focusing on a variety of policy, education, and other projects. Murali has a wealth of experience in pharma and the Indian judicial system, which we will uncover in this two-episode series. Unfortunately, this will be an audio-only episode as we faced some bandwidth issues. But as Murali jokingly put it once, quote, I have a great face for the radio, stop quote. But I really hope the quality of the conversation makes up for it. So without further ado, let's get into the conversation. Hi, Murli. Welcome to Shortcast over Coffee.
But thank you for having me. Great to be here.
Yeah. I'm going to start off with what I asked one of my previous guests, economist Ajay Shah. I was discussing with him policy making and climate change and so on and so forth. And one thing that propped up in my head was about the 6 week, or I think it's 6 to 8 week vacation or holiday of Indian courts in the summer. I was asking him if there was an interesting story behind it, and just want to put that question across to you as well. Is there any other country that has this 6 to 8 week holiday in the middle of the summer, and how has that affected speedy redressals?
The historical basis of this is that you had English judges and the summer was unbearable in India. So the English judges would go either to the hills or many of them would go back to the UK. So that is the origin of some courts having a summer vacation. So the Supreme Court has a summer vacation, the high courts have a summer vacation, and they don't coincide. So the summer vacation for the High Court in Bangalore doesn't coincide with the summer vacation for the Supreme Court in Delhi. So each of the high courts has a different period of time when they go on summer vacation.
Yeah, why have we not been able to change it? Is it just a colonial hangover?
So let me answer the previous question you asked, which is, has any other country got a summer vacation? And the answer is the United States Supreme Court has vacations. So it's not an unusual Indian thing. The reason people think that the courts are on vacation is similar to you and I going on vacation is that they don't see the courts during vacation. Most of the setup in the court continues to work during vacation. So the office works, you can file your cases during vacation. There are judges who are not on vacation or holiday even during that time. So if the court strength is in the Supreme Court 34, half of them will actually be in court during vacation. So we have what are called vacation benches. So the court is actually working. What is the other half doing? Now, the half doesn't sit, the same people don't sit the whole vacation. Okay. So some judges will take the first week off, some judges will take the second week off, third week off. So in the end, you will find at least half the court is working throughout the vacation. The other half, during the 2 months of vacation that exists, will probably take a week off on real holiday. The rest of the time, they have a lot of administrative duties. So if you're a high court judge here, you will be touring the subordinate courts in the districts. You will then be looking at how are those courts functioning? Does something need to be done to help them? You will actually be going and visiting those courts. And those are in the districts. So that is one part of your job. The other part of it is during the regular days and weeks, they would have heard a lot of cases. When does one get the time to sit and write judgment? So a lot of the vacation time will be spent on either administrative duties like this or on actual judicial work, which is drafting judgments. So it is not as if the courts disappear like it was in the British times, that nothing happens during that time. Judges actually work more hours and more days than most people do. So I think it's a myth that judges take off 6 weeks and then have a great holiday overseas and come back. The one other thing they do is participate in conferences. So a lot of them will go and conduct seminars for high court judges, will go and therefore help with professional education. So just like you would have amongst doctors a continuing professional education, a lot of judges also participate in that. So we have a National Judicial Academy in Bhopal, and you'd have Supreme Court judges actually going and spending time in these judicial academy, either in the National Judicial Academy, and each of the states has its own judicial academy. So in their area of expertise, they will also go out there and help other judges get better. So there is a lot of that professional education, continuing professional education that judges are involved in. They also have, as part of the administrative duties, lots of committees that they are on. So, for example, there is infrastructure of the courts. Somebody has to deal with that. There'll be lots of administrative procedures. They're on committees in the administrative side as well. So there's a lot of this work which otherwise piles up because during the working week, they will have no time to deal with this. They're sitting in court 10 to 4:30. They're reading for the next day, and it could be about 100 files to read for the next day. They have to check the orders that they've given in court. So somebody would have typed up those orders and they'll bring it to the judge at the end of the day. So the judges will actually have to read that order and check if it is exactly what they said in court. And then those get published, the orders get published. So during the working day and working week, they have absolutely no time to do anything else. So all of this piles up. And this is what they will do during the vacation. Not just the summer vacation, there is also a Diwali break in Delhi. In Tamil Nadu, for example, there is a Pongal break. So it is not the same in every high court, the breaks they have. Totally, it may be the same number of days, but they have it during different periods of time, depending on which high court it is. So you will have puja holidays in Calcutta more than you will have, say, Dasara in Calcutta. Whereas Karnataka, in Bangalore, you may have a Dasara break and you will not have a Pongal break. So in the end, you will find that it's the same number of days all the high courts are working during different times of the year, perhaps. The summer breaks are not all at the same time everywhere. But the judges in the end up working, I think, a lot more than most people think they do. So the cause for not delivering speedy justice is not court vacation. There are many other causes, but it's definitely not court vacation.
Mm. Yeah, thank you for breaking that down for us because these are some of the little known things that you said about judges attending seminars and performing some mentorship. Definitely, you did bust some myths there. And now moving to just law in India, the courts. There is this common narrative that the redressals are slow and there is a lot of time spent. And I want to take you back to your episode with Amit Verma on the seen and the unseen. Uh, there is no incentive uh, to go behind a case where you spend close to 20 to 30 years of your life to get a judgment, and again the judgment in your favor is still a probability. So where do you see this going? Is there anything being done to for speedy redressals? And what is your take on the general state of courts in India?
I think the problem is well known. It is more well known now than it was earlier because now we started gathering data. Earlier, it was large numbers, but we didn't really understand what they were. So we'd get judges saying, I have disposed 98% of the cases, or you would have individual judges being praised for their high disposal rate. So these are the terms that were used, continue to be used. What we've now got is some initiatives, both by the courts themselves and by research bodies. So, one of the things that you spoke with Ajay Shah was about a project that they were doing on looking at efficiency in the system. And they have a very good research paper out on a series of cases that they've done. We've got another organization called Daksh, which has done some really good work on this issue of understanding what it is that the courts are doing. How are they classifying these cases? What are the kinds of cases that are not getting resolved quickly? What is moving quickly? So we're getting a little more data. But the government solution to all of these problems is still ancient. So the government solution to this problem is, oh, there are lots of matters pending in a kind of case, say land. Let's have a tribunal for it. Or there are lots of income tax cases. Oh, well, let's have a tribunal for it. Or there are lots of IP cases. Let's have a tribunal for it. There are lots of consumer problems. Let's have a tribunal for it. There are lots of environmental problems. We'll have a national green tribunal for it. So the 80s was a proliferation of these tribunals. So they assumed that if we get more judges, we will solve the problem. These will be specialist judges with specialist knowledge, and we will solve the problem because it will all not end up being either in the civil court or in the high court. So I think what happened then was there was an understanding within government that if we get lots of these experts doing specialist areas of the law, we will be able to resolve these issues without coming to generalist judges, which is civil courts or the high courts. And this was about a 40-year project. It started off with the tax, but it then went into everything else. And the solution to the problem was if we get more judges and more courts, we will resolve these issues quicker. The problem with that approach was that the quality that was produced in the high court was not easily replicated in these tribunals. So nobody took these tribunals to be a good substitute for the high court, which meant that you had people in those tribunals who didn't have the quality of a high court judge. So you couldn't replicate that quality in there. Much of what they said in their judgments got appealed. So it didn't really solve the problem, except that you got one round of dispute resolved. A good example of this is the income tax appellate tribunal. You have 4 levels of appeal. So you first have an assessment of your taxes, which is by an employee of the tax department. Then, if they don't like it, if the department itself doesn't like its own officer writing an assessment of it, or if you don't like it, you will go and appeal. To who do you go and appeal? To another employee of the income tax department. And let's assume that person says, yes, 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 the Indian citizen is right. The department goes in appeal over itself to itself one more time at the tribunal. The tribunal, again, doesn't have truly independent members. They're all former employees or current employees of the tax department. And let's take the next case, right? So you have one in every stage. You win also in the income tax appellate tribunal. The government goes in appeal again over it to the High Court, and then again over it to the Supreme Court. So here you have a situation where the government is unwilling to accept its own decision and then continues this litigation. And it happens to many, 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 many cases. So in the rest of the world, if you have a government authority giving you a decision, the government will not appeal it. Whereas in India, the government itself will appeal it. So in every one of these cases, you will find that whichever is the losing side is unwilling to accept the decision. And there
Is
are two
that
reasons for it.
because government, I mean, all these government organizations are not centralized, which is why government is appealing itself?
No, this is the income tax department, which is a central government department. But there is no trust in the quality of what that assessing officer is doing, the Commissioner of Appeals is doing, the Income Tax Appellate Authority is doing, the High Court is doing, or even in many cases, the Supreme Court is doing. So we have cases where it has gone to the Supreme Court. The Supreme Court is held against the government. And what does the government do? It amends the law retrospectively. So that is how the government approaches the courts or litigation, that it will litigate this to death. And the government is the largest litigant in this country. So if we reduced government litigation, just private party litigation is not significant. More than 50% of the cases is by the government. By sheer numbers, the government is the largest litigant, especially in the higher courts. So that is our first problem. Before independence, courts were not so logjammed with cases. So we have a situation where when the Supreme Court was first set up, it didn't have enough cases. Judges had nothing to do for most of the year. If you see cases before independence or soon after independence in any of the high courts, there was hardly any pendency. Things got sorted out in months. We got decision in months. And very few cases got appealed from the High Court up further to the Supreme Court. So we can find some inferences from this. One, that the parties accepted the decisions of the courts and didn't continue to litigate. Two, that the quality of these decisions was quite good, which means that lawyers felt that it would be not worthwhile to challenge these cases up. Those are the two fundamental, I think, inferences we can draw from what was happening earlier to what is happening now. So, what has changed? Our perception that the decision is good and just and fair has changed. Secondly, we have government which should lead by example, but chooses to litigate everything all the way to the Supreme Court all the time. So if the government doesn't trust the judiciary, then it's very difficult for the common man to say, yes, we trust the judiciary. Then you have the lawyers who are inherently interested in litigation going on forever. So they will say, listen, you have a fair chance in the next appeal, and you have a fair chance in the next appeal after that. And citizens think, yes, this is what our lawyers are saying, this is what the government thinks. And we have seen cases which should never have gone in appeal winning. So everybody then gets hope that the next time I have a good chance of winning. And we haven't done enough analysis to look at what cases go in appeal, how often do they win, on what grounds do they win. As a result, the Supreme Court is dealing with cases which it should never deal with. Should a tenant be given 30 more days before he is evicted from his premises? Goes up all the way to the Supreme Court. Should a husband pay 1,000 rupees more per month to his wife as maintenance, interim maintenance, pending divorce? Goes all the way to the Supreme Court. Now, the Supreme Court doesn't trust the high courts. The high courts don't trust the lower courts. Therefore, everything goes to the Supreme Court. This didn't happen before independence or soon after independence this happened. Post independence, we just have lost faith in the judiciary. We think somebody up there can do a better job than somebody before us. And therefore, there is a chance. That has spurred on too much litigation. And the Supreme Court is largely to blame for it. It just lacks discipline. It is meant to be a constitutional court, but 90%, 99% of the cases have nothing to do with the Constitution, don't require an interpretation of law. They're just orders. So everything goes to the Supreme Court. That is causing pendency. So if the Supreme Court can hear everything, then the High Court can hear everything. The High Court can hear everything, then the court below them can hear everything. And that goes on and on and on and on.
Yeah, it's an interesting data that, well, not pure numbers, but at least from your experience, is that things going all the way up to Supreme Court started to increase after independence, and to me it feels like you know a combination of factors, right? Like you mentioned, lawyers giving uh, people hope, and then saying that, hey, you have a chance of winning it. And what I want to get to is, why did it start from independence? Because a lot of what we have in India, the judicial system is borrowed from what the British gave us. So why this sudden spike from 1947? Was it the lowering of the bar of judges, or uh, just not so much faith in the lower courts?
Many things have happened. I think the way we perceive the judiciary has changed dramatically. In the pre-independence, soon after independence era, we accepted the verdict. Whatever the verdict was, we accepted it and said, this is an independent judiciary, we accept the verdict. And there is very little chance that the High Court will strike down this order. High courts decided to intervene more and more, which they didn't do earlier. Why did they do that? Because they saw the Supreme Court intervening more and more, which they hadn't seen earlier. So the message seems to have come from the top. We will hear everything. So every little application from the civil court goes all the way to the Supreme Court. A tiny application, whether some small matter, interim order from the civil court goes all the way to the Supreme Court. Interim order from the family court goes all the way to the Supreme Court. So every little order of every little court now has a chance in the Supreme Court, which didn't happen earlier. So the Supreme Court starts the top and says, listen, we will be a constitutional court. We will not hear any of these matters. And we will impose costs, which is real costs, not 5,000 rupees, real costs of litigation on the losing side, which is there in the law. The Code of Civil Procedure very clearly says the losing party pays. But in no case does a court actually award costs. So the UK, from whom we borrowed this system, has a very clear principle that the loser pays. Therefore, anyone who thinks about going to court has to budget for their own costs, their own lawyers, plus the other side's costs, which doesn't happen in India. So everybody's basically bought a lottery ticket in court. There's no downside to it, to litigation. So if you look at incentives, the big disincentive to litigate elsewhere in the world is that you have to pay a price for it. In India, you're not paying a price for it. Take the majority of the cases, the civil cases, where let's assume that there is somebody who you have tenanted your home to, refuses to pay rent, you want to evict that person. Now, if that case is going to take ages to get decided, and it goes in appeal every time, and at the end of it, what happens? At most, you will get back your property, but you won't get all that lost rent. Now, if the tenant realizes that, hey, I have to pay market-based rent every day that I'm in this property, then the tenant will think twice. And if you add 18% interest to it, then suddenly the tenant will think, listen, I can't afford to pay my lawyers, the other side lawyers, rent, and interest. Then suddenly you look at the behavior of that tenant. Similarly, if you look at commercial transactions, somebody owes somebody money, somebody's in possession of land, somebody hasn't delivered on a contract. If you suddenly make this a purely commercial basis for decision making and allow economics to function, you will suddenly find a lot of rational people in India. Today, it makes no sense to be thinking in this manner because the incentives are that if you've got a property, you just sit on it. If you've got somebody else's money, never pay it back. If you owe somebody money, don't bother paying it back. So the incentives are all wrong. And the court system hasn't done enough to change this mentality. So we have a culture where people don't take the law seriously because there is an incentive not to follow the law.
That is that's quite crazy, to be honest. So I think the key takeaways would be that appealing is cheap uh, when it should be actually expensive, and the onus is on the Supreme Court to push that, hey, we are not going to accept anything and everything. We have our standards, and you have to accept what the verdict of the High Court. Is that a fair assessment of where um, law is in India and where it should go next?
Yes, if it's led by the Supreme Court, the other courts will follow, impose costs, make sure that there is uh, a clear economic analysis to be done by anybody. This is exactly what happens in the UK, that even if you think, I don't think this is a fair judgment, but am I going to risk, 400,000 pounds going in appeal? The answer will be no, because the risk of losing that is a lot more than what you've lost already in the first round. So it dissuades a lot of people from going in appeal unless they have a very good chance of winning. And
Hmm.
there isn't a good chance of winning. If you look at the appeal rates in the UK, they're very, very low. In India, virtually everything gets appealed.
Makes sense. Yeah. You were mentioning about data coming in, and there is a lot of data these days. Could you dive deep into the quality of data and how data is collected, and the evolution of courts in adopting something computerized systems from, let's say, the early 1990s to now?
We've had very little success in the early years with data collection. It is because we don't have a uniform system of recording the data. So each state has a slightly different way of doing everything. Each court in each state has a slightly different way of doing everything. So it is very difficult to find national data that makes sense. So aggregation doesn't work. Then you're down to states. Now, the head of it all is the High Court in the state. The High Court itself doesn't follow a uniform system of recording data because it was all paper, so it didn't really matter. So the first stage is trying to get all of this data classified in a uniform manner and then seeing how workflows work. So, the rest of you in I think the tech world and uh, industrial production and all of you guys understand how workflows happen. In the law, we haven't sat down and done that exercise clearly for each high court. So the way you classify something is so uncertain that it's very difficult to track. It is not that something comes in appeal. It comes in appeal in so many different forms. So you can have a civil appeal, you can have a criminal appeal, you can have a miscellaneous appeal, you can have a first appeal, you can have a second appeal, and you have applications in each of these appeals. So it's very difficult to keep track. It is not as if the whole case moves somewhere. It is just one application that may go up somewhere, and that has a life of its own. And depending on where it ends, you start again from the bottom. So each of these things is so uncertain for data to be collected on it that there is a huge cleanup process that needs to get done. Now, that is something that only started a few years ago. He's trying to understand from a design perspective what is happening. How do these cases move? What is the life cycle of this? Where does it start? How many loops does it go through? So, just that exercise has just started. So, the Daksh research, and I think Vidhi did some research as well, they're all trying to figure this bit out. Is take this, try and classify them properly to be able to get data on them. So that's how low down on sophistication we are. The computerization of courts is really, again, at a very, very, very early days. We have only now got to telling you what the court will hear tomorrow. So if you go to the website of the high courts, only the high courts, you can figure out what is coming up tomorrow. You can figure out in most cases, but not all, what a little bit of the history of that case is. So when was it heard previously? What order was passed at that time? And in the cases that have finished, you might get a copy of that judgment, but only for the last few years. Many courts have said, we will allow you to file electronically. But that again, in the government sense, is that you upload it or email it, or you give a soft copy, but you also have to give a hard copy. So we haven't completely eliminated paper. The Supreme Court is really the one that has led some of this computerization. So, at least with the last couple of Chief Justices, they've tried to eliminate paper. So, they're saying don't file paper, don't bring paper to court. They've got rid of a lot of paper in court. They're all using, laptops and tablets in court hearings, discouraging lawyers from using paper. So, we've had judges tell lawyers, listen, we're not going to hear you with paper references. We're going to have a consolidated bundle. So there is a PDF. It is labeled and indexed in a particular order. Please refer to paragraphs and page numbers from that. So we are all able to look at the same piece of paper or the same page. That has been a move. It was started a few years ago, but during COVID, it's really taken off. And now, at least in the Supreme Court, you have many judges were unwilling to look at paper. So they've all got laptops in front of them or tablets. They insist that the lawyers should use tablets. So at least that part of it, which is filing, accessing schedules, agreeing that we're all looking at the same piece of paper with the same index, the same page number, that has happened in the Supreme Court. Now, it's a long way to go before it trickles down to the high courts and the civil courts and the lower courts.
Yeah, I think COVID must have accelerated a lot of these processes, right? Just by force and not by choice. It would
Yeah.
also be great if we could digitize all the pre-computerized era papers. And I think Indian Qanun, I see a couple of websites that are doing it. I don't know if they are digitizing it verbatim, but there is still a lot of resource. Um, yeah, you mentioned about Daksh and Vidhi, some independent research organizations. Are they receiving any support because they are taking up a task that is going to shape the future of how courts function if they get to where they want to? Are they receiving any support from the government in their endeavors?
I don't know for a fact, but many of their projects will not be possible without the government and or the judiciary wanting this to be done. Well, let me put it differently. If the government and the judiciary didn't want it done, Daksh and Vidhi and the others could not have done it. So the fact that it is happening means that somebody in government and a few people in the judiciary are keen for this to happen. I don't know what kind of support they're getting, but clearly the fact that it is happening means that they are being supported. Now, can the government do more? Obviously, yes. Can the judiciary do more? Obviously, yes. But at least a few of these organizations are able to do research, are able to put out these numbers. They seem to be credible numbers. However, we may think about their level of sophistication of some of this analysis or the numbers themselves, it's a great start. We need more of this to be done. You must understand also that the judiciary is not a monolith. So you can have, let's say, a chief justice of one high court, if he really wants to drive change, can make it happen. So we've seen with Orissa, Justice Muralidhar has done a spectacular job there in the 2 years that he was there in driving digitization, driving technology, and also, as you said, COVID helps.
Yeah, yeah. And I think yeah, I mean, as I asked the question, I was wondering, who else will fund the research, right? The big corporations do not have a stake in improving the state of law in India or the courts. And, they should receive funding from somewhere unless they are so passionate that they pool in their own money. So, yeah, it completely makes sense that they must be getting some sort of funding from the government. I
They
happen
also
to,
get donor funding, don't forget. So a lot of these places do get donor funding. Uh, Vidhi, I know, has private donors as well, institutional donors. So does Daksh. So there are people interested in law and justice who think of access to justice as being important. It is an SDG, so there are interests involved in this. There may be interest from tech companies because they benefit. So if you look at WebEx, for example, Cisco is benefiting from it. So there's clearly some interests involved in moving the agenda along.
oh, yeah, that's a great point. Um, I came across one of your speech collections. The speech is State of Indian Legal Profession, Where Can We Go From Here? And you mentioned in the speech, quote, it is no wonder that no one in India thinks of perjury as an offense, but rather as a rule. Stop quote. Uh, is that a big problem, ethics in with Indian lawyers? And what have been your observations over the years?
Lawyers are only part of the society as it is. So you can't expect a higher ethical standard from a lawyer than what prevails in society. Lawyers are not saints. So if you have a society of sinners, then we're just one of you. And that is the challenge that as a society, we are quite casual with the truth. We don't think of it as a big thing. Even in our own personal lives, we like to think that we are truthful, but it's not a value that we cherish. Uh, it's nice to put it on the emblem and say Satyameva Jayate. But we lie regularly every day in our daily lives. And it's a truly Indian trait. And we don't think less of it. You don't see this in the rest of the world. I've practiced in the United States and in Europe. Generally, you will find that people rarely lie. It's just not a thing. It's much easier to be honest. Simple things like, why were you late today? I missed the train, I missed the bus. I partied last night and, couldn't wake up when the alarm rang. It's very basic stuff. They don't lie about it. They won't lie about, I sent you an email. Have you not seen it? The checks in the mail. Have you not received it? This is very common Indian things we lie about. Why were you late? It's always traffic. Why did you not get this thing done? Of course, I got it done. I sent it to you yesterday. Very common Indian traits. And this is how we grow up with lying all the time. I know I'm lying. You know I'm lying. Everybody knows I'm lying. And we find no shame in lying at all. So that then translates into what happens in court, which is people are lying. So lawyers are lying. The clients are lying. Everybody knows everybody is lying. So we've accepted that as a standard. And nobody's ever got punished for perjury. So you've got a combination of these two things that lying is acceptable. And again, what is the incentive? Everybody lies, hoping that my lies are better than your lies, and I win. And there's no incentive on anyone to stop it. So if judges took it seriously and punished clients and lawyers, which is what would happen in the UK, then you won't have any of it. You won't even have minor mistakes. It just doesn't happen that a lawyer in the UK has the same duty as a lawyer in India. The rules of practice are virtually the same. In India, we have to verify what the client says in court. So whatever is filed by the client through the lawyer is verified by the lawyer. It is the same in the UK. But here, nobody verifies anything. We encourage clients to lie so that they can win the case. Whereas there, even if it was a slight error, it may not be hugely material. It may not be the complete story. The lawyer's future career is at stake. And therefore, no lawyer will take the risk of even getting close to the line. We'll stay clear of any controversy on this. It's easy to get caught, and the consequences are drastic. Now, if we had that standard in society, we'd have that standard in court here. The example I often give is Jeffrey Archer, future Prime Minister of the United Kingdom, going to jail for what most men would lie about, being seen with a prostitute. It's as simple as that. It was unacceptable to lie, and he went to jail. That's the level of integrity one expects. So if you
Yeah.
don't have that here, this is the consequence. Everybody lies.
Yeah, I mean, people ask me what was the biggest difference between, studying in India versus studying in the US. And I think this is one thing that I tell people is the honor system that I noticed here in the
Yes.
US. And I had the fortune of being like a teaching assistantship first year of my grad school, and my first sort of stint was grading papers. And you know, I did not go to school in the 90s. It was like 2014 and 2015, where there was a good access to internet, and almost all the level 101 courses had answers all over the internet. You could just do a Google search and you could get the answer and write in your homework. But the number of people who accepted the honor system and just would do what they know was remarkable. And I was putting myself in their shoes, and I was like, will I be this ethical if I was in their place? And I the answer was no, because probably the system, I shouldn't blame the system because it's me, right? But somewhere or the other, it does play a role that the thing about ethics. Yeah, and what amazes me is that India being so loose with respect to law, there are minor scams and land deals and corruption, but overall it still remains, it does not become a lawless country. Let's say something like a Syria or an Afghanistan, like there are these civil uh, things that people do when it comes to buying and renting property and so on, but when it comes to crimes, this lawlessness has not translated to more crimes, or am I wrong there?
No, you're very wrong there because uh, our crime rates are exceptionally high. Our reporting of crime rates are where they are expected to be. So we are not even honest in recording actual crimes. So that's our problem, that because we don't record enough, we look lawless compared to the developed world, but on par with other developing nations, perhaps. So there is a huge impact of not complying with the rule of law that doesn't ever get recorded. So I'll give you a simple example. If you look at the under trial population in Indian jails, it's a large number. They shouldn't be there at all. They don't ever get access to court. So their case never gets heard and they're stuck in jail. They have no access to justice. So if you had to go to a police station and lodge an FIR, the policeman has no interest in lodging the FIR, in investigating the case. So what happens? The crime doesn't get reported. If the experience of communities is that there is no point reporting the crime, then the crime never gets reported. If the crime never gets reported, the perpetrators of the crime will therefore now be emboldened to continue with larger and larger, more and more crimes. And that is the reality of India, which we don't see. The data doesn't show this in the way it should. But if you go back and see this kind of data, how many crimes are actually reported? How many crimes are actually solved? How many convictions do we get for the reported crimes? How many convictions do we get for cases that go to court, which are less than the reported crimes? And then look at unreported crimes. Then you have a completely different picture.
Hmm. Yeah, you also talk about law academics engage with the shaping of the law, and you note in your in one of your articles that that aspect is much lower in India compared to the Western world. Why is that? And engaging law academics in shaping the law, how can it improve the law itself?
The teaching of the law has had an impact on how teachers view themselves. So if you go to, let's say, an engineering school, they are producing engineers, not researchers, not scholars. So it is a very vocational approach to the profession. So you will find the same thing with law in India, that you have to get a degree so that you can practice a profession. They don't see themselves as academics, they see themselves as teachers and trainers. You perhaps realize it more when you're in the US or you're in Europe, that universities are a place for education. I remember often Oscar Wilde saying, it's where you learn to play elegantly with ideas. That is not the purpose of legal education in this country, has never been. It has been to train people like you train plumbers or you train electricians. That is the mentality that they've had here. Therefore, you don't have academics actually contributing to progress in the law. There are very few good academic journals in India which deal with legal issues. There is no requirement to publish for academics. You get on the UGC scale and you get promoted by seniority. It's only in the last few years that you have to publish somewhere. And you know the story of academic publishing in India. Anybody will publish anything for a price. And so to tick the box for your promotions, you can write any garbage and it'll get published. So there is no, again, where is the incentive for academics to participate in the progress of the law? It is very strange that I say this because one of the qualifications to be a judge of the Supreme Court or the High Court is that you're a jurist. So one of the categories under which you can be made a High Court judge or a Supreme Court judge is that you're a jurist, and that is academic work. But we have never, in the 75 years, appointed anyone to a High Court or a Supreme Court on the basis of that qualification. So it says something, isn't it? That we've
Yeah.
appointed lawyers, we've appointed judges, we've promoted judges, but we haven't found one academic in 75 years who's good enough to be a High Court judge or a Supreme Court judge. So why would a teacher in a law college or a law school be incentivized to do anything except if they are self-motivated to publish? We're seeing a little more of the publications in the last decade or so. We've got truly young academics producing good work. But again, there is no engagement with the judiciary. How many of them are preparing, like they would in the US, amicus briefs to the Supreme Court or to the High Court in important matters? Very few. So again, if they wanted to engage with the law, they would work closely with where the law is today, rather than write papers about where the law was 30 years ago. So that I think is the big challenge. The younger academics are engaging a little more. They're writing about contemporary topics, contemporary ideas. Their work is being cited by the Supreme Court, but we need to see them take the next step and say, we will write a brief, we will go and present before the Supreme Court. That hasn't happened yet.
Mm. Yeah, I mean, you have broken things down so remarkably well that, my whole perception of law and the court system in India has changed. So that was the end of part one of my conversation with Murali Neelakantan. Definitely check out part two, where we talk about pharma, manufacturing practices, and quality control. Bye for now.